802 keeps hearsay from being used as substantive evidence unless one of the many exceptions in Rules 803 or 804 applies, to say nothing of 807. Rule 805 governs hearsay within hearsay. It states that each time a statement is transmitted from one person to another, a hearsay exception must apply or the statement cannot be admitted. Some intended assertions, however, are defined as non-hearsay. These types of statements don't require any hearsay exceptions, even if they themselves are based on hearsay. A statement that is excluded from the definition of hearsay is freely admitted, regardless of how many intermediaries there are between the declarant and the witness. Rule 801D lists the statements that are definitionally non-hearsay. There are two categories. The first category deals with prior statements of any witness, including a party. These are admissible only if the witness can be cross-examined about the out-of-court statement, meaning that the witness remembers and will answer questions about the circumstances under which the statement was made. The exclusion applies to certain prior inconsistent statements, prior consistent statements, and statements of identification. A statement inconsistent with the witness's testimony that was made under oath in an earlier proceeding or deposition is not hearsay, because the jury ought to decide which of the two sworn statements, the one made during trial or the one made in the earlier proceeding, is the truth. A statement that is consistent with the witness's testimony is not hearsay, but only when used to rehabilitate a witness who has been impeached on certain grounds. Finally, a statement identifying a person after having seen that person before is not hearsay. Although the rule concerning prior inconsistent statements was broadened by amendment in 2014, originally, it allowed only statements used to rehabilitate a witness accused of having concocted her testimony. In United States v. Tome, the Supreme Court undertook to decide whether Rule 801D1A codified the common law's requirement that a prior consistent statement have been made before the declarant had a reason to lie. The issue turned on what it means to rebut an accusation. Prior statements rebut an accusation of dishonesty only if they were made before there was any reason to lie. Justice Scalia's concurring opinion emphasized his view that the common law is a more authoritative source on the meaning of the rules than the advisory committee notes are. The four dissenting justices simply argued for a rule that would give trial judges broad discretion in admitting prior consistent statements. The Supreme Court's interpretation of Rule 801D1A's rebuttal requirement is consistent with the common law's general disapproval of bolstering witness testimony. This is similar to Rule 608, which is the rule governing impeaching a witness's character for truthfulness. It allows evidence of honesty only to rebut evidence of dishonesty. The common law disapproved of bolstering witnesses, both because of the potential to mislead the jury and because it would make trials much longer, as the Tome majority noted in Part 2D of its opinion. Statements of identification made after having seen another person and then recognized him or his photograph are not hearsay. As California Supreme Court Justice Roger Traynor explained, memories of what another person looked like fade more quickly than other memories. Out-of-court statements of identification are also generally less suggestive than those made in court. This is the one instance in which an out-of-court statement is deemed more reliable than live testimony in court. The second category of non-hearsay statements are those made by or on behalf of the opposing party. Rule 801d2 is what gives effect to the warning that anything you say can and will be used against you. It applies equally in criminal cases and in civil cases. The rule provides that one party can introduce an opposing party's statement as evidence. However, a party cannot introduce its own statement as evidence. Rule 801d2 is always the easier and better avenue for admitting an opponent's statement than relying on any hearsay exception. The rationale for allowing these statements in freely is that the opposing party can always take the stand and explain or deny the statement. Of course, for a criminal defendant, that entails waiving the privilege not to testify. As the Supreme Court unanimously held early in the nation's history, when the court had only 7 justices, the admissions doctrine applies equally in criminal and civil cases. The rule covers statements made personally by a party, statements of others adopted by a party, and statements by a person authorized to speak for a party. Rule 801d2d covers formal agents or employees, while Rule 801d2c covers those authorized to speak on certain subjects, like an accountant who prepares the party's tax return. The rule treats conspirators as each other's agents with respect to the conspiracy. It applies regardless of whether a civil or criminal conspiracy is alleged. So long as a conspiracy exists, it doesn't matter what the claims or charges in the case are. Because these provisions derive from agency law, they apply whenever the statement was within the scope of the agent's duties or function and was made in furtherance of those. Any conspirator's statement that helps advance the conspiracy toward its illegal goal is the statement of all the conspirators. Statements that are merely about the conspiracy but do nothing to advance it, even in a small way, do not qualify. Conspiracies are more difficult to prove than traditional agency or employment relationships because conspiracies are secretive. At common law, a trial judge could not admit a statement as a conspirator's statement unless there was independent proof that the declarant was part of an existing conspiracy. In Bourjaily v. United States, the Supreme Court held that the rules of evidence departed from the common law rule. Trial judges can now consider the statement itself in deciding its admissibility. The court left open the possibility that the statement alone might suffice to establish its own foundation. In dissent, Justice Harry Blackmun, joined by Justices William Brennan and Thurgood Marshall, pointed out that the rule codified the common law and should be read to have incorporated all aspects of the common law rule. The Tome majority used this very same rationale to interpret the section dealing with prior consistent statements. But in that case, there was no conflict with any other rule of evidence. Justice Blackmun's dissent also emphasized that courts had long recognized that conspirator statements are not exceptionally reliable. Justice John Paul Stevens agreed with the majority that the plain text of Rule 104A and its advisory committee note authorized the trial judge to consider the conspirator statement itself, together with other evidence, in deciding whether a conspiracy existed, the declarant was part of it, and its illegal goal was furthered by the statement. 10 years after Bourjaily was decided, the advisory committee amended the rule, adopting Justice Stevens' view. It foreclosed using a purported conspirator statement to alone establish the foundation for its admissibility. The committee extended that requirement to statements of authorized speakers, agents, and employees as well. As the Supreme Court reminded us in Crawford v. Washington, the admission of a criminal defendant's confession has long been problematic in joint criminal trials, where the confession also incriminates one or more co-defendants. In such cases, there is a risk that the jury will use a confession not only against the defendant who made it, but also against the co-defendants. In such cases, the co-defendants will typically have no opportunity to cross-examine the declarant, who will exercise his privilege not to testify. The confession is testimonial hearsay, however, with respect to every defendant except the one who made it. For a time, federal law dealt with that by assuming that juries would follow the judge's instruction to consider the confession only against the defendant who made it. However, it was only too obvious that asking a jury to consider a confession that implicated two defendants against only the one who made it was asking too much of anyone. In 1968, the Supreme Court reviewed a case that provided an opportunity to repudiate that legal fiction. George Bruton and William Evans were charged with armed robbery of a contract postal station. Evans was questioned while in custody for a separate robbery, and he implicated Bruton. They were tried together. While the case was pending, the Supreme Court decided Miranda v. Arizona. Evans's conviction was overturned on appeal because it was obtained in violation of Miranda. Bruton's conviction, meanwhile, was affirmed because the trial judge had told the jury to consider Evans's confession, which implicated them both, only against Evans. Evans was acquitted at his second trial. On these facts, 5 justices agreed that the conviction violated the Confrontation Clause because it was impossible to believe that the jury disregarded Evans's confession in deciding Bruton's guilt. Justice Hugo Black concurred only in the result, and recently appointed Justice Thurgood Marshall did not participate. Justice Potter Stewart joined the majority and wrote a short separate concurrence presaging Crawford. Justice Byron White, joined by Justice John Marshall Harlan, dissented. He argued that the court's constitutional decision excluded reliable evidence from trial, underestimated jurors' ability to concentrate on only reliable evidence, would limit joint trials, and would make the criminal justice system less efficient. Justice White's hostility toward excluding what he considered reliable evidence from criminal trials would, in later cases, like United States v. Leon, distort and diminish the Bill of Rights.